Hello, everybody. Thank you so much for joining us, and welcome to part 12 of the Environmental Law Institute's ongoing series, Community Lawyering for Environmental Justice. Today, we're going to be talking all about heirs property. My name is Sarah Viken. I'm the manager of educational programs here at ELI. If you aren't familiar with the Environmental Law Institute, we are an internationally recognized nonpartisan research, publishing, and education center working to strengthen environmental protection by improving law and governance worldwide. I want to take a moment to thank all of our speakers for taking some time out of their busy schedules to spend with us today and share their expertise. Now I'll go ahead and turn it over to our wonderful moderator, Miles Marborough. Miles is a law fellow at Wake Forest University School of Law's Environmental Law and Policy Clinic, and we're absolutely thrilled to have him joining us for the discussion. So without further ado, I will go ahead and turn it over to you, Miles.
Thank you. Welcome, everyone, and thank you for joining us for today's conversation, which is going to focus on heirs property. For today's conversation, we do have two fantastic panelists who I'm looking forward to hearing from. And I'll just say a little bit about them before we do hear from them. The first is Jamie Loudermilk. She is an attorney with Brooks, Pierce, McClendon, Humphrey, and Leonard, where she counsels clients in complex business and family litigation, including heirs property, bankruptcy, insolvency, and nonprofit matters. And her practice is based in North Carolina. We also have Scott Konowski, who serves as general counsel at the Center for New York City Neighborhoods and its wholly owned subsidiary, Sustainable Neighborhoods, which is a community development financial institution and a tax-exempt mortgage lender. And Scott's practice is based in New York City. So we have a conversation full of attorneys who are heirs property attorneys who are working in various capacities to help people keep their home or their land in their families, and a lot of great perspective on this topic. So before we do dive into this conversation, just as a general kind of framing of the conversation, if we're thinking about the intersection of heirs property and environmental justice, what really are the interactions and synergies there? When I think about that, I think obviously these are two topics that are rooted in race and place, related to individuals' rights to enjoy and to preserve the places where they live and exist in community. And so hopefully those principles will guide this conversation and maybe guide some of the questions that you all are going to contribute, and hopefully we'll get to answer toward the end. So for Jamie and Scott, let's start out with the basics. What is heirs property? And what is tangled title? I hear them used interchangeably. What is it that we're talking about when we say heirs property or tangled title?
Yeah, can we have the next slide, please? Yeah, so I just give a little bit more context. I come from a legal services background. I directed the Homeowner Stability Project at the City Bar Justice Center here in New York City for about 13 years. And there we did all kinds of work around preservation of homeownership. But a lot of it was around disaster relief, like in the wake of Hurricane Sandy, for example. Or it was preserving that family home intergenerationally. When somebody dies, making sure that the next generation can continue to live in that home and they can, access all the benefits of home ownership. It also involved foreclosure defense, but it was out of that project where I really got, involved in the heirs property world, which is like a very expansive, growing sort of community and network of lawyers and practitioners and advocates nationally. And this area has really been built out in the last really like 5 years. And there's an heirs property practitioners network and everything else. So that's just a little bit of background of where I come from and how I got here and what my organization now does, which I'll touch upon later. But really, it's like, what is the overarching question? What are we talking about? And there's heirs property, and there's tangled title, and there's all these other things that my colleagues here will describe. But heirs property very simply, is just any home or land that you inherit from a relative. Grandma dies and she owns, 100 acres of farmland, and she has 4 kids, and she passes away without a will or other estate planning, and that property just passes automatically to her heirs by operation of law. And every state's a little bit different about that, and we'll get into that in a minute. But just very broadly speaking, heirs property is land or homes or other property that you just inherit from another. And there's some overlap between what heirs property is and tangled title, and I think it's also regional. A lot of people refer to heirs property as tangled title, but I think of tangled title as something that's broader. And maybe Jamie, do you want to describe like the different kinds of names that we call all this different kinds of titles that are out there?
Yeah, sure. I do first want to say good morning and thank you everyone for being here. This is such an important topic that even I think a lot of people don't realize when they have some real property interest that is vulnerable. And so just being a part of getting the message out and familiarizing yourself with the language in the field, it's huge. So thank you. I am primarily a litigator in Greensboro, North Carolina. And so I come from a varied background. I was a AmeriCorps Vista volunteer after Hurricane Katrina down in New Orleans, and I spent several years with the U.S. Forest Service out in Montana. I've always been passionate about people and place. And so in law school, I learned a little bit about heirs property, and to the extent that I can offer my services pro bono, usually for litigation. And it's a small part of my practice, more on the preventative side. So great to be here. And in terms of tangled title, clouded title, we actually had an offline conversation, the presenters did, about who uses what words in what context. Clouded title is probably the more discrete, accurate legal term to describe when there is an encumbrance or a claim or some other, quote, cloud on a record title to the land. And we'll have some slides about this, but on the chance you are totally new to the realm of real property, what we mean is if you own a house or if you own an acre of land, you have title to that by way of a deed. And that deed is, quote, recorded in the county where that land or that house is located. And everyone else in the world that knows how to do this can determine who, according to the record, owns that land by looking at the chain of title. You'll hear us use this vocabulary a lot, and we will try and give context on the chance these terms are new to you. But we've also learned that ChatGPT can be useful in this realm, as can Google. So clouded is probably the more discrete legal term. Tangled title, depending on the region and the context, is something that is much broader. And then we were really arriving at offline that depending on who you're talking to and the extent you are familiar with these terms, really unclear is what describes any matter of situation where it is not readily understood from the public record who owns that piece of property and can bind the owners of it in terms of what can happen on the land or how the land can be transferred. Yeah, I think that's next slide.
Great, thank you, Jamie. So what I hear us saying is that there is heirs property where, folks have inherited land and that is creating unclear title, but there are also all of these other issues that might come up with title, which can still be encompassed in the type of work that people who might consider themselves heirs property attorneys or tangled title attorneys are still doing. And so what are the stakes then of having heirs property or having tangled title? What is the concern from a legal perspective?
Yeah, and that's really the crux of the whole conversation is how do we address tangled title heirs property issues when they arise and when we want to serve our clients? And it comes up in all these different ways. When I was doing direct legal services, it came up if say somebody fell behind on their mortgage, they had some kind of hardship, and they're in the process of dying, and you have the next generation, the children who are taking care of the parents in the home, and everything's in chaos and disarray. How do you, the title holder passes away, how do you stabilize that home ownership? How do you deal with the mortgage? How do you transfer title, so that the next generation can assume that mortgage loan or pay off the debts or whatever it is? But then it also comes up, and this is where this came up in all the scam prevention work that I do now and I did before. If there's a single title heirs property issue, if the owners of that property who inherited it don't have a recorded deed, even though they own that property by operational law, that property is often subject to predation by speculators and investors and people who are looking to strip that equity and that value and that wealth out of the home and out of these communities. It comes up, if in for our purposes here, all around environmental issues and climate change and disaster response, flood recovery, and all of those things, and to access benefit programs like home repair loans for resiliency, or in response to a hurricane, and getting FEMA benefits if you have tangled title or unclear ownership. Then the way it used to be is that you didn't qualify for any of those programs. And I mean, those are sort of the main areas that I see, just that basic preservation of the property, the land, the home, all of that sort of stuff.
Just add a little bit to, not as nefarious, but this can also arise in property owners being at risk of forced tax sale, because there are various different heirs. They're in various places. They don't even know maybe that they're record title holder. They are not getting mail from the county where the land is located. They might live across the country. In North Carolina, one case I've been involved in is down in Wilmington, and again at the intersection of environmental justice. Hopefully most people know, but Wilmington is the site of the Wilmington massacre. And so that there are Black families that survived and retained real property and now maybe are at risk of losing it, is just a very compelling opportunity for us to protect people that we didn't protect previously.
And so I hear y'all saying that not having one's name on a deed to your home because it is inherited, or for any number of reasons that there's some type of cloud on the title, can create these myriad issues that can affect people in all of these different ways. This probably sounds silly to y'all as heirs property attorneys, but I know that in my conversations with folks trying to explain the stakes of heirs property, I have sometimes gotten the comment, well, when my family member, let's say when my grandmother passed, then we just probated it, and then we sold the house, and then we all split the proceeds, and now everything's fine. What's the issue? And so I think there's a cultural piece maybe, or just some differences in the reality of how it works for some folks and others. Can y'all speak to why it isn't that easy in most cases that we work with, at least?
Yeah, definitely. And this just comes from all of my experience of working on the ground and in the field. And it's what do we call home, or community, or a place? Well, where do we go back to, and all of that sort of stuff. I mean, I think about my grandma's house, and that was sort of a central place where everybody, like the cousins went, the aunts and uncles, and everybody just knew it was there. And when people were housing unstable, they'd go and live in grandma's house, or they would, just always have that as a backdrop. And especially if say it's a family farm or something where you have close connection to the land and roots, and like you're deeply rooted in a community, whether it's rural or it's urban. It's not as simple as let's just sell the land and distribute the proceeds. When folks actually rely on that housing. And especially in a place like in New York City, and this really comes up, let's say in, historically like Black neighborhoods that were artificially depressed. I think we're going to get into this in later slides as well, but you have property values that were artificially depressed because of discriminatory, systemic racist laws. That was there was an attempt to address that with the Fair Housing Act, but it just did not go as far as it should have. But there were redlining practices and things like that that artificially depress those values. Fast forward 50 years, and those are all the most rapidly gentrifying neighborhoods in New York City. And you have a home that was worth $30,000 for 50 years ago, that's now easily worth $4 or $5 million, like a Harlem brownstone. And it was still a place that family called home. And to this, grandma may have passed away 40 years ago, but you still have like cousins who are living on one floor, family members living on a second floor. So, and that's kind of where it is. But I think you were also getting to another question. Maybe I'll let Jamie jump in if she wants to.
Yeah, sure. Well, I mean, I think that answered maybe part of Miles's question, and I'll just add that my sense, the more I'm in this work, is that inherently death is uncomfortable. We don't think about our own death very much. We don't, as soon as I would like for myself and my colleagues, get our death plans on paper. And historically marginalized communities rightly suspected that the legal system was not looking out for them. And so there is long been a tradition in thinking that if you didn't do anything, and if you just kept your family, you kept your land or your house in the family, then it would stay within the family, that protected it somehow. And so part of the outreach campaign is that it's not, if you do nothing, if you stand outside the legal system, unfortunately, that makes you more vulnerable. And so our advice now is, to the best you can, embrace the fact that at some point we all are going to die, and that we need to engage with the probate process, as nerve-wracking as that may be, as early as possible in thinking about how we protect our family's assets and how we make things as simple as possible for the generations that we want to care for after we are gone.
Yeah, and to build on that too, is what we're talking about mostly here are individuals and families that don't have estate plans, and they haven't in a way they haven't determined how to deal with the family home and land and assets once the patriarch or the matriarch passes away. And there is a cultural element to it. I can't talk to it because it's not my lived experience, but I witnessed it. And there's disproportionate levels of access to effective legal counsel and estate planning services. And also, just I feel like there's a lot of distrust with the legal system for people who have been historically marginalized, like Jamie describes. And we can get into the sort of the historical context here too, and this goes all the way back to Reconstruction era and Jim Crow laws and access to legal systems, and just the systemic barriers that had been built up to make it difficult for people to access the system to protect their assets. And so there's definitely a lot of distrust out there about legal services, and kind of like what Jamie's talking about. It's like, how do you bridge that gap? How do you communicate and get to the communities that might be affected by these heirs property issues?
Yeah, I think all of those cultural pieces that you all mentioned are really important. And Jamie, something you said made me think about, sometimes because it has been the practice of the family for so long to try to exist outside of the legal reality of estate planning and how real property title descends, that by the time we get to, a recent person who's deceased, it was already an heir's property for generations before that person. And so lots of times I've had, a family member come and say, oh, well, we need to figure out what to do with grandma's house. But then come to find out it was actually great grandpa's house. and it's already an heirs property. So I think that historical context is important. And then Scott, you were mentioning some of the kind of macro historical context, talking about Reconstruction. Can y'all talk about, I guess, about that context, about land loss that heirs property or tangled title has created, and where that exists? I know that we have somebody from North Carolina and from New York City. We're kind of displaying that heirs property is everywhere, but nationally, where is it concentrated?
Should we go through a little bit more of the property details first? And then, because I think there's a
100%.
that you inserted, Miles. I'm super visual, so I'm like looking out for anyone else. That's like,
No, please do,
where
Jamie.
are we?
Yeah, because and I think the context conversations are really important. And I guess to that point, yeah, we should maybe lay a little more of the groundwork around the nuts and bolts of real property and title ownership and how to address these, and then talk about the historical context, what we've done to address the creation of heirs property proactively, but also the response when an heirs property case comes into our door. But then also, I think that the next half of this or next part is really about how this relates to environmental justice and all the efforts that we're doing well, I guess the intersections of environmental justice and heirs property. So yeah, maybe the next slide.
This one I'll jump in on. Again, I just wanted anyone that's not familiar with property law or hasn't owned a home yet. When you become a homeowner, you have a deed to the house and the land that makes it yours, and that's recorded on record title. The image on the left hand of the slide is an example of sort of common language you'll hear depending on what area of either the financial system or the legal system you are participating in. But what we are in particular focused on at the core of the conversation around heirs property is at some point, someone came into record title ownership by a deed or a grant that it is defendable at law. And so that interest has passed forward through generations and is shared across potentially hundreds of people. And this document on the right is what people have in mind when they are saying, well, what's the granting deed? Where does this start? Who first owned this? And what's the record proof of that?
Yeah, and maybe the next slide, please. Yeah, and so let me just run through some real, like take a step back and run through all the basics of property ownership, real property, and the forms of ownership. And this is just, I was a real estate lawyer forever, and then I was a foreclosure defense lawyer forever, and then I was heirs property lawyer, and now I'm general counsel, so it kind of all comes together in a big mix. But so the most simple form of property is fee simple. Like when I, as an individual, I have a deed, my deed's in the land records. I have fee simple title to this home. It's very clear. When you purchase that home, you get title insurance. They look at the records. That's fee simple. Most people own their property in fee simple. Tenancy in common is when there are multiple owners, and it's a default form of ownership in probably every state, most jurisdictions. And so that's when, let's say I inherit property from my brother, and I inherit property from our mother, and without a will, we take that property as tenancy in common just by operation of law. So we would each own a 50% interest in that property, and I can transfer my interest, I can sell it to somebody else, I can mortgage my interest without even asking my brother. And so if I do that, if I sell my 50% interest, then he is now a tenant in common with this third person. And this is really relevant when we're talking around about the predation of heirs property and all the scams that we see. Tenancy by the entirety, that's a protected form of ownership specifically for married couples. And it's if you are married and you and your spouse purchase that property together at that same time, then you take that property as tenants by the entirety. Most of the deeds will spell that out. They'll say you like Scott and Eli bought this home together as a married couple. That means we're tenants by the entirety. We could also say Scott and Eli as tenants by the entirety. That will appear on the deed. Joint tenancy with right of survivorship. It's a similar concept, except it's not as protected as that marital right that you have under tenancy by the entirety. Before we got marriage equality, for example, this was a common way for same-sex couples to hold title because they didn't have those protections under tenancy by the entirety. And that just means that I take that property with Eli as joint tenants with right of survivorship. And so when I pass, my property automatically goes to Eli. But either one of us could break that up at any time. I could sell my interests in the property, and all of a sudden Eli owns that property as tenants in common with this other person. Whereas in tenancy by the entirety, that doesn't happen. Like that's protected. And so Eli and I, if we're married, then I sell I can't sell my interest, I can't mortgage my interest. And that came up in mortgage cases that I had where a lender messed up their underwriting and they had only one of the married couple signing a mortgage. They can't enforce that mortgage right then. Life estates was something that we were using as a form of estate planning light. And that's if, let's say I own property, say my grandmother owns property and she's late stage of her life and she wants to pass that property on to me and avoid probate, avoid, all the issues around having a will. She can prepare and record a deed that says, that gives her a life estate in that property. And then when she passes away, that property automatically goes to Scott in fee simple. That's what a life estate deed is. Co-ops and condos, I don't really need to talk about that much. I mean, condos, both of those are multi-joint forms of ownership of apartment buildings usually. Co-ops is a very specific New York thing. A few other jurisdictions have it, but you'll hear, especially in New York, I think there's like 1 million units of co-ops, and that is not actually even real property. Co-op ownership is like you own shares in a corporation that owns the land, and then you have the corporation leases the shareholder, the unit that's assigned to that lease and that share. So it's a very complicated structure. We don't need to go into it, but it also complicates heirs property issues. And Jamie, I don't know, did you have anything you wanted to add here?
For folks that are coming at this brand new, we hope this slide provides both broad context for how this fits in both the legal field and also within the environmental and social justice categories. On this particular slide, the category that is the most prevalent and the most important to understand is the tenancy in common, that second category. That's what we'll be talking more about today. And to give you an example, my husband and I own our house in fee simple. It's the first home I bought. And if we divorced and one of us moved out the house, we would then own that house as tenancy in common. And I heard Carla Carter, who is another attorney on here today, she explained this really well once to a potential client. Once you own real estate or a house, a land or house in tenancy in common, you own shares of a pie. And so you can borrow against that share of the pie, but you can also give that piece of the pie away to the detriment of other pieces in the pie without their knowledge and without their consent. And that's really what the crux of the issue is for a lot of heirs property families.
And maybe just to build on that example, Jamie, in the heirs property context, right? The reason that, as you said, tenancy in common is so prevalent is because when someone dies, the state says who their heirs are according to the state law, and all of those heirs become tenants in common. So just by default, that's how state's property law gives title to people's heirs.
Well, thanks so much for linking that back. When we spoke earlier about why it is detrimental to not participate in the legal system as a family with real property interests, if you do not execute a valid will, the state by law decides who inherits the real property, and they inherit as tenants in common, which means any one of them can undo what may have been your intent to keep the land in the family. And I often wonder why the law developed the way it did. And there's a whole philosophy class we could probably teach on that. But in this particular context, it's important to remember that this is a capitalist system and real property is central to capitalism. It is a basic resource. I actually meant to screenshot a North Carolina law on this, that it is the intent of the state that real property be freely alienable, that it be able to be sold, that it be able to be divided, that it stays within the market and is moving unless it is being valuably used. And so that is sort of the backbone of how we got to today on the legal side and the financial side.
Yeah, and just to and to even build on that further, like for example, in New York, the way that the laws of intestacy work, when somebody dies without a will, and when property passes by operation of law, and it's different in every state, so you have to look at your specific statute. But in New York, for example, if you are a married couple and one of you dies without a will and you have no children, then the spouse gets the entirety of the estate. If you're married and you have children, then your spouse gets the first 50,000 of your estate and half the remainder, and then whatever is left is divided equally amongst the children. If there are only children and the spouse is predeceased you, then all the children get that estate in equal shares. And then if there's no spouse, no children, it goes to parents and it goes to siblings, it goes to cousins. So that's just an illustration of how it works. And so imagine if somebody at that generational level didn't resolve the estate, then the next generation you have, say like this generation, you have 5 heirs who own this property as tenants in common, including like the spouse that owned this 60% interest and the children that own, so let's say 10% interest each, and you still didn't resolve it, then all of those people, their heirs all get a share of that estate now. And so by the next generation, you might have like 10 heirs. And by the next generation, you might have 30 heirs and 100 heirs. And it's a real case scenario that has really happened. And we'll talk about that some more in a little bit of the next slides. But let's touch on this one.
Yeah, thank you for that context, Scott. And I think I kind of jumped the gun on this topic, but I was just wondering if, with regard to what this slide shows, if y'all could talk about, you all are in 2 different parts of the country. When we're talking about heirs property, are we talking about a regional issue, a national issue? Is it different in different places?
And I can jump in here unless, Jimmy, you want to go first. So all of us really became aware nationally of the heirs property problem when, and everybody's attention was brought to it really, when there was these developers who were going after undeveloped farmland, coastal land in the Gull Islands and in the coastal South. And you'd have, say, like 100 acres of coastal land that had been farmed continuously by the same family, generation after generation, for, since the Reconstruction era. And it was great-great-great-grandpa who had acquired that land coming out of slavery. And so it was prime coastal land, and the developers saw an opportunity and they went after one fractional interest of that land, and they were able then to displace the people who were living and farming that land, who owned the land. They stripped the wealth, and then they developed that land into golf courses and other things. So that's kind of the context, and we'll get into that a little bit more in some of the later slides too. But I really noticed this issue in New York City about 7 or 8 years ago. And it just because, we saw these scams happening, and it was basically the same thing that was happening in the rural South on these valuable lands. That practice had come to the urban context. And so there's so much more to talk about in this area too, but I just want to get back to the main point here is like, where do we see heirs property? Where is it concentrated? And, it was thought that this was mostly like a rural issue around farmland and timberland and, developers going after and trying to appropriate that land for their own profit and other things. But then once we all started digging into this, we saw that it was an urban problem as well, and it was the same exact thing. It was the appropriation of these homes and this real property and this land and this wealth, that it was easy target because of the historic laws. And so there's been all this work and study around to try to quantify the extent of heirs property across the country. And initially it was more of a rural focus, and so that was where most of the studies had started. But then the most recent studies have also included urban heirs property in that calculation. And this right here, I think, is probably the state of the art chart of where it is. But as you can see on this chart, there's a high concentration of heirs property in the Southern Black Belt, for example, and there's a high concentration of heirs property in the colonious regions in the borderlands, Texas and New Mexico. In places like New York City and Philadelphia, you see high concentrations of heirs property in historically Black neighborhoods like Harlem and Bed-Stuy and Jamaica, Queens, and those sorts of places, those neighborhoods. And so that's kind of that context. I don't know, Jamie, Miles, do you have anything more to add there?
Miles, you may be able to speak better to sort of the prevalence in North Carolina. I haven't really looked at it from a broad incidence perspective, but I will say from my experience, what has been most interesting to me is that it is very much, so far as I can tell, a class issue for a lot of people. There are certainly some people with assets, and I mean assets to broadly mean not just wealth, but access to the systems that help you generate wealth. So like familiarity to the legal system, comfortable relationships with the banker, that kind of thing. And so like in North Carolina, a huge concentration in the eastern part of North Carolina, both rural and urban. And then also in the western part of North Carolina, where we have white Appalachia, poor Appalachia, there are certainly people of color out there. But this research has really taught me that this is an issue that is impacting families that don't have access to the systems that are designed to protect property rights.
No, I definitely see that as well, Jamie. And I think it goes back to the point of, yes, there is an estate planning gap, but also, as we mentioned, some folks, die without a will, and then the estate is managed easily. But the difference is that lots of folks just need housing for multi-generational families, and that social context, more so than the lack of estate planning, in some cases, is what is going to make heirs property more prevalent.
Yeah, and maybe the next slide, but I'm
Yeah,
sorry.
can I say one more thing? I'm sorry.
Yeah, of course.
I came into heirs property from more of an ag side. I'm always been very passionate about sustainable farming and cooperative farming and regenerative farming. And what really drove me to try and better understand what has happened in North Carolina is the numbers I saw around Black farmland loss. And this issue explains, unfortunately, a lot of that, and it is ever present. And I feel, and the others that I'm connected with in North Carolina feel, that there is a real urgency to try and save what can still be saved of Black farmland.
Yeah, and similarly, the same thing in the urban context. I mean, New York City, we're losing a lot of the New York City born Black population because people are being forced out and priced out. And a lot of it is around the loss of the home and the predation of the home. And maybe that'll lead us into the next slide. So what is predatory partition of heirs property? And this is, I started describing this in that context of the Gula Islands in the South and the developers going after historically Black held farmland that had, that was a throwback to the Reconstruction Jim Crow era. But what is predatory partition? So that was the legal tactic that these speculators had used to appropriate that wealth and appropriate that land. And there's traditional partition law, and this goes all the way back to our common law origins. And if you own property jointly with somebody, you have an absolute right to use that property to do with it your interest whatever you want. And if the person that you own or the people you own that property with aren't cooperating, then there's some legal recourse, and that's by bringing a partition suit. And so the traditional partition law is you bring a partition lawsuit and you ask the court for relief. And that relief is partition in kind or partition in sell by sell. And partition in kind is, let's say you have 100 acres of, prime coastal land that you own with your brother, and you and your brother can't agree on what to do with that property. You go to court and say, can you please partition this in kind? And that's the default version. And that just means that the court will say, okay, you get these 50 acres and you get this 50 acres, and just divide the land into each person, each co-owner walks their way. If you can't divide that property, then the court will look at partition by sell. And for example, in Harlem, if you have a Harlem brownstone on a tiny, tiny lot, but that Harlem brownstone is worth $4 million, you can't cut that brownstone in two and give each sibling, half of that brownstone. You have to sell it. That's the only way that you can deal with it. But the speculators, the predators, they saw this as an opportunity. They went and went after each of these individual fractional owners by operation of law, and they would acquire that fractional interest. It could even be a 1% interest that cousin Joe in LA owns and didn't even realize that he owned, and they'll pay them, some nominal amount of money for this interest that they didn't know that they even had. And then once that speculator gets that 1% interest or whatever interest they acquire, then they can go to court, file a partition suit, and force a sale of the entire property. And if they do that, then, the way that these judicial sales work is that they're never fair. You never get the fair market value. We know this from the foreclosure context. On average, you only get about 60% of the true market value when there's a final forced judicial sale of the property. And in this context, it's even worse because you have like a developer who's deep pockets, and you have these heirs who aren't. And so you don't, it's not really even a fair marketplace at that judicial sale. It never is. So anyway, that was the main way that the property was being divested from the true owners, stolen from the true owners. But then also, in like the New York context, for example, you have three heirs. You go to one heir on the $800,000 home in Queens, which is a normal price, average home price in Queens, and the investor will pay $100,000 for a 1/3 share to one of the siblings who doesn't like the other siblings, and they'll go to the next sibling and pay $100,000 to that sibling, and then you have the holdout who might be living there. And this is actually a true story. This happened to one of my clients, and the investor is like, okay, I'll give you $100,000 for your share, and if you don't give it to me, then I'm going to file this lawsuit. And most people don't understand or know the complexities of the legal system, to understand how to file an answer to a complaint or like even that threat, and they don't have access to legal services. And so you kind of have a choice. It's like, do I sell this interest for $100,000 and walk away, or do I fight it and try to maintain something? And the partition laws were awful. And this is before all the law reform, because they would ding the brother that was living in the house, taking care of it, taking care of mom as she passed away, and they would deduct all of his usage of that property for the 20 years that he was living there. So at the end of the day, you have this investor pays $200,000 for 2/3 interest, and they're probably going to get most of the equity if it actually goes to that forced sale in court. So this is why it sucks, why it's awful that exists in partition law, and why there's so much law reform. And Jamie?
Yeah, I'll just add to, since I'm hopeful that a lot of the people participating today are curious about potentially serving as pro bono counsel. And so there's sort of two contexts in the ways in which you could be able to help. One is on the front end in more of an estate planning role. And then one is on the defensive end, which is the role that I've played more. And that's when somebody has a petition for partition filed against them. And it is a co-tenant owner, and many times they don't know this person that has filed this petition and has a legal basis to ask the court to sell the house irrespective of what the other owners say. And the other owners don't have the financial capacity to outbid the person that brought the petition. I've linked down in the bottom of this slide a short news story about a home in Wilmington. That family, it's actually two properties. One, we're not at the numbers up in New York, but one is about 200,000, one is like 350,000, I think. And they are within a couple blocks of downtown, and they are in a little bit of disrepair. And I don't know, but I think that the information for this family was researched in the chain of title, so publicly available documents. The investors hounded them outside their house, like sat in a parked car and waited for the matriarch to enter and exit. She's in another city. Found another niece that allegedly has a small interest. And I believe it was like a day after her car accident, pressured her to sell her interest. I think paid a couple $1,000s for it. And they now have a piece of this pie where they share it with at least 7 other people. And that is enough for a petition for partition, which this family has been fighting for a couple of years now. I just want to say, sorry, Scott, I think that answers one of the questions in there. I've been trying to keep track of the Q&A. The other questions in there, we're either going to get to them or we will specifically address them at the end, but keep the questions coming. They're very good. Go ahead, Scott.
I was just going to say, can we have the next slide? So this is a real life example of what we were seeing in New York City, and kind of addresses one of the Q&As as well, the questions in the Q&A. So I had a whole series of clients who were coming into our project who were the victims of some kind of scam or felt like they were being scammed. And these brothers' names kept popping up, and they're popping up on the deeds. They'd acquired some interest, and then they were forcing a partition sale. And so I got an investigative reporter to look into it and just do some research. And what they found was just crazy, shocking. I thought it was like a handful, but they had acquired over the course of just, I don't even know how many years, like 2 to 5 years, a total of 119 properties. And you couldn't really trace in the land records that it was them. And you can only look at like the signatures on the deeds and things like that, because they'd set up individual limited liability companies for each one of these property holdings. And so it kind of hid that trail. And there's been a lot of conversation about unshielding the identities of people, investors, and members in these LLCs out of this. But we're talking about 100 and just in this, there's probably a lot more, just in this, out of that research that these investigative journalists did, they found almost 120 properties. And so we're talking about, if you average those homes at 800,000, how much is that? Like $100 million of real estate that they have appropriated. And you can see in the graph here that this is so disproportionately affected communities of color. The dark purple are majority Black neighborhoods, and all the dots of those properties that they acquired are primarily in those neighborhoods. So that it's very targeted. It's very much a racial justice issue. We'll talk about later how it's an environmental justice issue. And can we have the next slide?
And I think you were headed in this direction, Scott, but maybe we could discuss, and I know there's a question in the Q&A as well about ways to prevent creating heirs property. So what are those ways that attorneys are using to help people prevent this title issue?
Yeah, and this is what Jamie was referencing too. This is the proactive estate planning side, getting access to estate planning, and this is where there's a real need for pro bono attorneys, and also just building up culturally attuned lawyers who know the issues when they're working with the clients that we serve. But I'll run through this quickly so we can get to the other part of the discussion. Estate planning basics, wills and trusts. Wills are super complicated. They can be expensive, and you really need an expert. You have to have, in New York, you have to have multiple witnesses, and you have to have all these different things. And so it's something that, if you use this online software, it's easy to mess up. If you don't have a valid will that you can't bring to, in New York, we call it surrogates court, but that's the probate court. If you can't probate that will, then you have heirs property. Trusts are even more complicated, and there are a lot of different kinds of trusts out there. There are special needs trusts. There's all kinds of trusts. I don't need to get into details. Our organization was funded to provide estate planning services and outreach, and to fund our partner organizations to do that work. And what we learned is people come into these projects and they're like, oh, I want a trust for my house. But they're so expensive and they're so complicated, and you can often get the same thing that you want out of that trust, especially with the client population that we serve, with a will. But then there are all these other estate planning light tools. We already talked about transfer investing of property interest by operational law.
And Scott, I was just gonna, sorry to interrupt, but I was just gonna say before we move off of wills, that some of the reasons that, at least in our experience, that we encourage folks to consider one of these kind of will substitutes that you're getting to is because the most common will that people want to write is to leave their real property to all of their children. And so then by trying to do the right thing and create an estate plan, they're still creating heirs property, because if you leave it to all of your children, then tenancy in common is the default still. So I just wanted to insert that quickly and then kind of frame the rest of these are kind of alternatives to that will.
And can this wasn't totally clear to me until just the last couple of years, because I am not regularly in the trust and estates world. But one thing I took away was that if I do nothing else in the world of heirs property, but I am, next to or involved with somebody that's putting on a wills clinic, and I make sure that that clinic is helping people understand what it means to either leave specific tracts to people, or otherwise, if you're going to do to all your children what that looks like for the children, that will be huge. It from my very layman's position, it seems like the message of people need wills is getting out there in all kinds of contexts. And now the message needs to be people need a certain kind of will to protect real property in the family.
Yeah, and that's exactly right too. And to add to that, because we have to triage a lot of the legal services that we provide, just because the need is so great and the supply is not. We've developed all these sort of estate planning light tools that get us to where we want. That isn't as complicated. And and going back to the wills thing, there's still a lot of people out there who think, oh, if I just write my last wishes on a piece of paper and stick it in a shoebox under my bed, somebody's going to find that, and then they're going to distribute my estate the way that I wanted it. But we all know here that that's not how it works. But when in the clinics that I used to run, we had we do an entire assessment of what the situation was. We'd look at existing title, make sure it wasn't clouded, it wasn't unclear, we'd untangle that title if we had to. And then we take that next step of what's your estate plan? Like, what do you want to do with this property when you pass away? And sometimes it's as simple as like, oh, I just want to leave it to my daughter who's taking care of me at home. And so in that situation, we could easily do a life estate deed, record that in the land records, and then when she passes away, her daughter inherits at home just by operation of law. We got all these reforms in New York last year, really great new reforms around the partition law, which we're going to get to in a second as well. And with that, we got transfer on death deeds, and that's a different kind of deed where I can record a transfer on death deed in the land records saying I want my property to go to X, Y, and Z or just X. And then, but then I can pull that back at any time prior to my death. And then, so like, if this is my favorite kid this month and that's my favorite kid next month, I can switch that around with the transfer on death deed. Or if this person dies and now I want to go to, my best friend, then I can do that as well. Ladybirds are kind of similar. I don't really understand them, but they're
I
similar
can
to
tell you the difference really quickly. A ladybird deed is the same as an enhanced life estate deed. So generally with a life estate deed, if I own the property and I'm giving my child the property, but keeping a life estate for myself, I no longer have legal title. I just have the right to live there for the rest of my life. With a ladybird deed or enhanced life estate deed, I'm doing the same thing, giving that child, in this case, legal title technically, but it's reversible. So I can turn it back around and do the same thing with somebody else, or I can sell it, or so it gives the original owner more control over the property.
Got it. That's a great explanation. And so it is very similar to a transfer and death deed, but there's some nuance there. The other kinds of deeds, like what do you do when somebody comes into your project and they've inherited a home partially or entirely by operational law and there's no recorded deed? What I would do, and I kind of developed this practice by copying the scammers, is I would find all the heirs, look at all the heirs. We do family tree affidavits from two people who are disinterested in the property, is what title companies did. And then we would we get somebody who's disinterested to sign those affidavits. We collect birth certificates, marriage certificates, death certificates, so we can confirm the family tree. And then we would prepare an heirship deed and would just say that, X, Y, and Z who inherited this property as tenants by the entirety by operational law or whatever, through the death of Y who died on this date, grant title to X, Y, or Z or however they want to do it. And that's the heirship deed. And it's not perfect because to make it perfect, you'd want to probate that will if there is one, or you want to go to surrogates court, probate court, and get letters testamentary or letters of administration. Administration is when there's no will. Letters testamentary is when there is a will, and that actually gives the court imprimatur that this is a real thing. And so then you have much better marketable title if you want to sell the home or mortgage it. But the good thing about heirship deeds is you get people in the land records, and you after 2 years of the passing of that person, then there's can't think of the word right now, but everybody just recognizes that that's true title. Let's move on because we've got.
Wait, can I say one thing,
Oh,
Scott?
sure.
I'm sorry.
Yes.
And Miles actually can answer this better. Isn't it state by state the extent to which transfer on death deeds and ladybird deeds are recognized? Okay, and did we make that clear? I just want to make sure.
Yeah, in New York, we just passed the law last year. And Miles?
No, go ahead.
Oh, that's all I really have to say.
Absolutely. Yeah, all of these kind of property law specific things are state by state. And so some places like North Carolina have very few of these options.
So national efforts, public awareness, estate planning, legal resources, and then the Uniform Partition of Heirs Property Act. And so maybe we should just jump straight to that, unless Jamie, Miles, there's anything here you want to talk about.
There's definitely questions about the Uniform Partition of Heirs Property Act, and it hasn't been passed in North Carolina. I hope it is passed, and many people that are attending this webinar know that there's offline conversation about strategies around how to pass it based on North Carolina is a bit, in my opinion, of a bellwether for the rest of the country. So we have had terrible gerrymandered districts for a decade. Some people think we have not had a democracy for that long, and that's now playing out between Texas and California. And so reforms like this are you have to think critically about the extent to which and how you advocate for the people that will benefit from them. So that's all I'm gonna say in this moment about the UPHPA.
So maybe next slide, and then I'll get into the very specifics about the UPH. Well, do we have a slide on the uniform part? Maybe we don't. So I'll just do a quick background on the UPHPA. So this was a law reform effort led by Thomas Mitchell, who's now runs the Heirs land. I can't name it. I don't know the exact title, but it's Boston College of Law. And he worked in the Uniform Laws Commission to develop the Uniform Partition of Heirs Property Act. And it's to address all those inequities in traditional partition law that I had described. And basically it tried to level the playing field and put all these protections for heirs who are caught in that situation where their home or their land was being preyed upon. So it's one of the most successful uniform laws. It's been adopted by 25 states now. And I think it's been introduced in 5 more. And in New York, we got it in 2019, after I got all this press around this predation, the speculation that we were seeing in New York neighborhoods. One of our local legislators had introduced the unmodified law, and the unmodified law is better. It better protects heirs property owners in the rural context. And so what we tried to do is modify it to make it more applicable to the urban context. And so so we put all these changes in the uniform partition law. I don't need to go into them because we're time restrained. So do we want to talk about title review and all of this, or do we want to jump into the environmental justice part?
Well, before we leave wills and estates, I want to show one thing. So this is a book I highly recommend. Is this gonna work?
Oh,
Maybe not. Okay, well, it's
Yeah.
Phil and Erica Levine Powers' book about heirs property and the Uniform Partition Act. If there are more detailed questions on how this came about and what it does, this book is fantastic. It does a great sort of analysis of everything that I think is coming up a little bit in the chat. And we're getting some backgrounds in the chat that we should skip title. So if you can look at the slides later if you want to understand how you figure out who, according to the records, owns real property.
So let's go past the title company stuff. So this is really I think a lot of the environmental justice people, this is probably the main reason why you're joining this conversation. And we also want to leave a little bit of time for Q&A at the end. So who should I just jump in? Jamie, Miles?
Yeah, please go for it, Scott.
Okay, so there's so many different ways that heirs property overlaps and touches environmental justice and just general equity, racial justice, economic justice. They're kind of all intertwined in so many ways. And I think of it in terms of disaster resiliency, disaster relief. It's in terms of access to programs. It's in terms of preserving lands and open spaces, and also returning land to its prior state. And hi, Fronda. I'm sorry, I think we got confused here because you're in a different time zone. Is that right?
That's correct.
So maybe we just went through all the title stuff. We went through, well, not title stuff. We went through all the background, heirs property, and the real property basics, and now we're jumping into the climate resiliency part. So maybe, do you want to take a minute and just introduce yourself and how you do all this work, and like what your intersection is, and all that good stuff?
Absolutely. And thank you so much, Scott. And thanks for inviting me to this panel. My name's Ferronda Brassfield. I work with the KKAC organization, which is an organization, our roots are in Arkansas, but we work in a number of different states, and we work to assist landowners, and participating in qualifying for NRCS programs. Once we started doing that very important work, we realized that many of the people that we serve were not able to participate in those NRCS programs because they did not have clear title to their land. So we developed the Heirs Property Clearinghouse, where I'm the director. And we developed the Heirs Property Clearinghouse to provide pro bono legal services to landowners, farmers, people that need to clear up their heirs property issues so that they can make their land profitable in whatever ways they see fit. Hopefully, they would be participating in a program with that would help them to build wealth on their property.
Fantastic. And Scott, I know that you were just mentioning, climate resiliency and disaster recovery. I don't know how, how much you want to talk about that, but I think that, I think about it a lot in North Carolina, where we're recovering from Hurricane Helene and the issues that people have faced getting access to resources because of not having their name on the deed to their family property, as you all mentioned at the beginning of the presentation. So I imagine that's part of that topic. Are there other ways that climate or disaster recovery is related to this topic? And Faronda, feel free to chime in as well.
Absolutely. So what we've seen across the country, due to climate change, we've seen a rise in natural disasters. And we've seen those natural disasters affect people of all classes, socioeconomic statuses. But the people that we end up working with at KKAC are those people, typically that the property has been in their land, in their families for generations, and they just simply don't have clear title to that land, and that bars them from participating in some of those economic disaster relief programs that would allow them to clean up the home site, to make whatever repairs they need to make. And that pushes these heirs property owners further away from economic viability for their property and for their land. And it's a process. They have family members many times that are all over the United States, and getting those people together and having the resources to get those people together and actually quiet title to the property is more than a notion for most of the people that we work with. And so that is one of our priorities. And another priority is making sure that these landowners can participate in programs like conservation easement programs that are going to help to sustain the environment in their areas, so that hopefully, we have created an environmental climate that will be less conducive to these enormously affected natural disasters that people are dealing with. And so if you don't have clear title to your land, again, you can't participate in the conservation easement program, which is also a wealth building program for many families that participate and many landowners that participate.
Yeah, the little bit I can contribute to this slide is there's an heirs property practitioner network of attorneys across the country that are in regular communication. If this is something that really becomes part of your practice, I really encourage you to check it out. One of the opportunities that's come through that I had an opportunity to talk to 2 weeks ago is the American Forest Foundation. And the American Forest Foundation is doing really neat things up and down, well, across the country, but particularly I'm familiar with what they've been doing in the Appalachians around a carbon program. And historically, that program has been available for landowners that own 30 or more acres and have clear title. They realized how exclusive that was to many Black landowning families and families with heirs property. And so they are now, as part of their family forest carbon program, they have set aside funding and are looking to work with heirs property practitioners in a few states for families that want to enroll in the program. It's a long-term commitment, but families that want to enroll in the program, they will try to work with the family to clear title, because the international agency that verifies the carbon credits, you have to be authorized to bind the land. So you have to have clear title in order to be in that agreement with the American Forest Foundation and the third-party verifier.
Yeah, and then I'll go into sort of the nuts and bolts of also these city and state acquisition programs to acquire the homes and land, and helping folks relocate to areas that are not flood prone or disaster prone, and putting those kinds of easements on the property, and then returning that land to coastal land or to wildlands. And I can't talk specifically about the conservation easement part, and maybe Rhonda, I think you probably have a lot more experience here, and so maybe you can touch on that. But the way that these programs are being developed is these city and state agencies who are doing the research, doing the analysis, figuring out which parts of the city and state are prone to flooding, either from what are increasingly more frequent crazy rain events that just drop a ton of rain. You've all seen the things on TV where the water's shooting up out of the New York City subway because of some crazy rainfall that happened. It seems to happen like every other month now. But when that happens, it also floods people's basements. People are drowning in basements. Then you also have the, Hurricane Sandy. We were involved in the Build It Back program and in New York City, New York State to help people, and that was reactive, who had lost their homes or homes were damaged, and helping them move out of these areas that you can see will probably be affected the next time around. And that was good, because at that time we then had federal assistance to do that. But now we're trying to do that proactively, and in a different kind of way. You're looking at those homes that are in the most likely flood zones, not just coastal, but like the Hudson Valley in upstate New York, for example, or in some of the mountain communities where you'll have these crazy torrential rains, and you'll have these inundated tributaries that wipe away entire small communities. So targeting those communities, getting working with the community, not forcefully displacing anybody at all, because we all know what Robert Moses did back battle days here in New York City, and targeting primarily communities of color and putting in highways and really destroying the fabric of a lot of communities. But getting that community buy-in, individual buy-in, helping folks relocate, pulling together different tracts of land, and then putting those conservation easements onto the land. So Rhonda, do you have something to add there?
Sure, I'd love to add, Scott, to that. Of course, the environmental considerations are extremely important. But for families that don't have clear title to their land, um, and they don't have the option of enrolling in a conservation easement and setting that land aside so that it's a protection for the community, for the environment, those people, and also for the family, being able to access that monetary benefit that many times lets you get the full value of the land while retaining ownership of the land in your family. Those families are faced with selling the land and no longer having land that's been in their families for generations. I know that there are so many buzzwords now, you just don't know what to say. Historically underserved, socially disadvantaged, Black. These are all words that have somehow become buzzwords. But the reality of it is that that has, things like this and these barriers from participation have contributed to the loss of heirs property and property that's been in the Black community for generations. And so if people don't have this option of participating in these programs, leaving some out so that the family can continue to have a piece of that land that they can do whatever they want to have a homestead, to have the land that they can come back to, that completely kind of eliminates their ability to hold on to their land, and many people have to sell that land. Whereas if they had clear title to the land, they could enroll in a conservation easement program, they could have that environmental benefit, and they could also have that land and keep that land in the family for generations.
And
Just
Rhonda,
add to that, in North Carolina, we've lost so much Black landowners. So even before you get to the environmental justice aspect is letting them make sure they can keep farming, and then also engage in the disaster mitigation, the recovery, the climate resiliency, but making sure that they keep farming and don't lose their land because of these predatory practices.
I was going to ask whether in North Carolina or in Arkansas, either of you have seen situations where a conservation easement is actually helpful in allowing a family to prevent fractionation or prevent a partition because they're able to use the value that they're getting from the conservation easement to satisfy one of the heirs who is wanting money from it so that the rest of the family can keep it. They now have clear title because they bought that person out. Well, that doesn't necessarily mean they have clear title, but they now no longer have the person who wants to sell the property. And
They have more secure title.
yeah, exactly. And they're able to get that conservation easement. I wasn't sure if that's something that you all have seen, because it's something that I think about a lot of how the environmental law can aid the title issue.
My sense is that a lot of the programs that are investing in getting funding back to landowners, to the extent to which marginalized communities, Black communities, these landowners can clear title, especially out in the eastern part of North Carolina, it is adding to the income base and just makes everything a lot easier and more secure going forward. This is anecdotal, but small farms, sustainable farms, regenerative farms, those tend to be the smaller practitioners. And that is, again, where we have to come in behind and help resource and protect who's still here so that they can continue to manage land in a way that's good for all of us.
Absolutely. And in Arkansas, we've seen the same, that the rates vary by state. I would throw out maybe about $3,500 an acre here in Arkansas in certain areas, and that's really the cash value. So what we have seen is the conservation easement and imposing a conservation easement on a portion of the land has enabled the family to keep the whole entirety of the land rather than having to sell the land. And absolutely, there are typically one or two people or a fraction of the people that want to extract the money out of the land rather than keeping the land. And this allows being able to enroll in the conservation easement has allowed the families to do both.
And someone asked in the general chat whether the conservation easement prevents partition. And my understanding is that a conservation easement runs with the land, meaning that it not only binds the current owners who actually sign on to the conservation easement, but it also binds the land in perpetuity. So even if that's the next generation of heirs, or if it's a completely different person, then the person who owns the land next owns the land subject to the terms of the conservation easement.
But if you have a conservation easement, the question almost is a little bit like cart before the horse. If you have a conservation easement on the land, you probably have a situation where even if it's not land that's been organized under an LLC or a trust, that the heirs are already unified under a tenant in common agreement, because everyone that has an ownership interest in that land has to agree to put a conservation easement on the land. And it would be hard for me to imagine a family getting to that point without also talking to and agreeing on paper that no one can sell an interest without the other heirs, for instance, having an opportunity to buy them out. It could have happened. It's a good question, but I think the question is more to the front end, if that makes sense.
And I can speak to that, and that's, because we're designing these acquisition programs right now, and we're working with the city and state agencies to do that. And part of the big challenge is exactly this: when you see a property that you want to put into one of these programs, so you can return that land to whatever and put a conservation easement, there are a fair number of these are going to have tangled title issues, and so you're going to have the legal resources and the knowledge to first of all identify those properties, and then get the legal resources to the heirs or the owners by operation of law, so they can untangle that title and get clear marketable title to actually put that easement on the land. I mean, I guess you could potentially have somebody, like, if you can't prove full ownership, it could be a partial easement, but the danger there is you have somebody come around who can prove that they own that fractional interest or partial interest or have a superior interest. And if they didn't ever agree to that easement prior to that easement being put onto the land, then that easement's not enforceable as to their interest.
Well, and like conservation easement, I've only been involved in one of these, but a title rep search is run. And so any reputable company that is going to pay for you to conserve your land is going to make sure that they have the authority to enforce that easement. That's what they're paying for. And so either they're going to pay for someone else to, or they're going to do their own title search to make sure that all of the people that have an ownership interest in that land are signed off.
And that's really the big question, is when we're designing these programs, like for example, when our organization dispersed the $500 million of federal COVID relief aid to New York homeowners, and it was a federal program, and we addressed the problem that came up with Hurricane Katrina. And Hurricane Katrina, you had all these homeowners who had tangled title, and they couldn't access FEMA benefits. They couldn't access that federal assistance, disaster relief. And since then, FEMA has changed its policies, so it expanded that access. But when we were designing the COVID relief program in New York, we made it very heirs property aware. And so if anybody could establish that they owned even a partial interest and they occupied that home, then they got that disaster relief benefit. Now, the question is, when we're designing these conservation easement programs, these acquisition programs, part of it is, first of all, we have to order title, we have to review title, see if there is clear, clean title. If there's not clear, clean title, then we need to provide those services to the heirs to clear up title. And then if you only can clear up, say, 80% of the title, and you have like Uncle Joe who disappeared 30 years ago, and perhaps he was homeless, but nobody knows if he's alive or dead, is it enough to have that 80% to get that conservation easement, knowing that there is a small chance that Uncle Joe comes back and establishes this 20% interest, and which he could sell? And that's exactly where that question comes up with, does that conservation easement, does it go with the partition? Well, he could partition potentially the property for us to sell, and I don't know, it's very complicated.
I know we only have 3 minutes left. I wanted to just wrap up and see if anyone had some final thoughts they wanted to share. I really appreciate the conversation and feel like so far what we've really touched on is that the title issues that heirs property owners have are in many cases exacerbating the environmental justice issues that their communities are already facing. And so to the extent possible, programs like conservation easement programs or programs like climate disaster recovery programs can incorporate and include folks who do not have clear title to their property, but are the caretakers of their property, are probably co-owners of their property, then that can aid kind of this discrepancy in who has access to these resources to promote environmental justice. Other final thoughts anybody wants to share?
There was a question that Scott said we'd send resources for in the small or family farm arena. And I really only know North Carolina, but if you're in the North Carolina area, please be in touch. I'd like to know you anyways. You're doing great work. Thank you. I put a link in the chat about this. I cannot say enough good things about the understanding heirs property at the community level training that the SRDC Southern Rural Development Center offers. They are offering a couple like across the country. It's like, I think there's 1 or 2 or 3 a year. It costs money and time to get there. And so I understand that this is not accessible to everyone, but if this is something you or people you're working with are passionate about, they take you through how to, like, you do enactments on how to talk to family members about death and about their land and where it's going and how to fix it. And they talk to you about how you can present to a church community or other sort of naturally congregating groups of people to try and help people protect their land. It's a really good training.
I mean, I think my only closing remark really is I just happened upon heirs property issues in my work, and I scratched the surface, and once I scratched the surface and saw what was happening, I couldn't unsee it, and I just saw it everywhere, and how heirs property issues, it touches on so many of the inequities that we see in our systems today, and just addressing these and just focusing on them and being aware of them in all of our work really does bridge that justice gap. And so I could probably speak to everybody on this call, like we're all very passionate about these heirs property issues, and we're all part of a large community of heirs property practitioners that are also very passionate. So get involved, be interested, and we welcome you.
Absolutely. I would, for final remarks, I'd like to invite everyone to visit our website to see the states that we serve and to call on us if you need our assistance with navigating NRCS programs, or if you need our assistance in clearing up heirs property issues so that you can enroll in those programs in your respective state. And I'm dropping our website in the chat. Thanks.
Thank you. Sarah, that's all I have. I'll pass it off to you.
Okay, thank you so much. This was a really helpful program, and I hope you have all found it as valuable as I have found it just listening in. Thank you to Miles, Jamie, Scott, and Fiona. We're happy you could at least join us for the last half hour. This was a really interesting discussion, and thank you again to the wonderful audience for helping to drive that with all of your questions. If you couldn't attend the full webinar, we'll have the recording up on the event page. I've linked it in the chat. Should be up later this week. And I've also put the link in the chat to the rest of our Community Lawyering for Environmental Justice series. So please check those out as well. All right, and that brings us to a close. We hope to see you all at future programming. And again, cannot thank all of you enough for this discussion. Bye, everybody.